We've seen Robert Cartwright give a complete closing argument, an introduction, an issue concerning liability, dealt with the issue of damages. But now we're going to reshift our focus, because any good closing argument, like any good story, develops and progresses and reaches a conclusion. That conclusion is usually to be found in some magical 5 or 6 moments at the end of the closing argument. So what we've done is we've taken 3 such situations. Bill Colson, trial lawyer from Miami, Florida, will present to you 3 cases involving damages and the issue of how to deal with them. Each one has a unique problem. The first deals with a young woman who is a quadriplegic, and it is the role of Bill Colson to make this injury come alive and have the jury translate that injury into something that is meaningful to them. Before you hear him begin, I want to call your attention to the fact that he will have a different style than Bob Cartwright. First of all, he uses the podium, but he does not use the podium as some type of an impediment between himself and the jury. He uses it on occasion, but when he wants to develop a point of particular intimacy, he'll pass beyond the podium and deal directly with the jury. There are 2 other argumentative devices that you should be aware of also. He is keenly aware of the need to create images. He is a good storyteller. He uses a realization of a truth that Aristotle recognized some 300 years before Christ, when he said, men think in terms of images. He wants the jury to think, and so he creates the images. Shakespeare, too, had that realization. And one of his most beautiful prologues that he put in the mouth of the prologue of Henry V, he said, think when you speak of horses, that you see them printing their proud hooves in the receiving earth. Well, if Aristotle and Shakespeare knew the magic of imagery, we lawyers should realize that too, and Bill Colson certainly does. The second argumentative device that he utilizes is that of alienation. Not alienation in the sense that we usually use the word. It's a term of art which means the capacity of taking a familiar situation, removing it from the context that we usually think of it in, and giving it a new perspective. Here he is dealing with a quadriplegic woman and how one usually feels in regard to someone who is quadriplegic. And he puts that into an entirely different context. And you'll find the effectiveness and the impact of his capacity of utilizing this technique of alienation. Let's watch Bill Colson in the first of his final 5.
May I proceed, Your Honor?
Proceed.
Your Honor, ladies and gentlemen, I know you're tired. And I know it's 5:30 and it's Friday afternoon and it's been 2 long weeks since you've been here. I know you came here a week ago Monday and we made a lot of selections of who'd be on this jury and who wouldn't. And I know you've wondered, why me, now that you've heard the tragedy that's involved in this case. And I know you've heard lawyers talk now for many hours. You've heard 3 sets of lawyers for 3 different defendants. And I know you're tired of lawyer talk. And I know that you'd like to go to the jury room and decide this case as soon as His Honor tells you about the law. But I don't apologize for taking these last few moments, because I've wondered about how I would feel in these moments as I shift the responsibility that's been mine for 4.5 years now, that suddenly is going to become yours when you go into that jury room. I'm not worried about shifting the responsibility, because I know you will do what you believe in your heart is the right thing to do. But I am worried that I've been able to bring to you on behalf of Mrs. Jill Brown everything that I should have brought to you, or that I've inadvertently left something out. And I've wondered what I would do at this moment, in these final 5 moments, as to how I could express to you the tragedy of this case. Go back with me now, if you will, to a week ago Monday when you were being picked. And just before you took your oath, the last question that I asked each one of you individually, and I looked you in the eye, and I said, now, one last question. At the end of this case, if the evidence shows and the law allows you to believe that we are correct in this case and that the defendants or one of them is wrong, under those circumstances, if the evidence also shows that there was a very substantial injury with a very substantial tragedy in this case, at that time, if we're right, they're wrong, will you be able to award a substantial sum of money? And each one of you looked me back in the eye and you said, you prove your case and I won't have any problem. And I asked you, will you be embarrassed or have any hesitation? The mere fact that it's a large sum of money, because it's the evidence that requires it to be. And each of you said, no, you prove it, and I'll do my part. Well, now you know. Now you know that they are responsible, that the defendants are wrong, that Mrs. Jill Brown is totally innocent in this case, that she was a lady 33 years of age, that she was a person who was enjoying life, that she was married, that she was pretty, that she had 3 small children, that she sang in the choir on Sunday but enjoyed life, and everything was going along all right until this horrible tragedy. And now you know, from seeing her for only 20 minutes out of 2 weeks, now you know that you're faced, as I've been, with perhaps the most serious tragedy in the United States, of a person who not only has been paralyzed from the neck down, who is lying in bed at home, who has now lost her husband who has left her, who is now seeing her youngest of the children, who is going off now, left, who's now in a position where there's no one left there except a 65-year-old mother who has a heart that's bad but still full of love, a heart that is taking care of her day and night. Now you know that you're faced with the decision as what is the correct thing for you to do about this case. Well, I've wondered, how do I explain to you what the word quadriplegic means? You heard the doctors explain it. You heard all of the anatomy. You heard what it really means, that you can't move from here down and that she'll be that way as long as she'll live. You heard the different opinions about her life expectancy. But what does it really mean? What can I tell you that it means from inside of me that you should consider? And what is stayed in my mind since early into this case is something that we used to do as kids here in Miami when we all grew up here. That was many years ago. But one of the things that we used to do is we used to go over to Miami Beach, and there used to be a lot of sand instead of hotels, and there used to be some trees, and you'd take the new kid that came from up north and you'd take him over to the beach. And there'd be 4 or 5 of you had taken the new kid, and you'd get out and you'd have a lot of fun. And one of the things that you would do is you'd dig a bunch of holes in the sand. And you'd get down in the sand and the other guys would cover you up. And you'd get down there, but you kept digging the hole deeper. And it kept getting deeper and deeper. And one by one, we'd all get in there. And one by one, we'd all be covered up until it was time for the new kid. And then we'd take the new kid and we'd say, get in. You know, you're one of us, go on, get in. And he'd jump in because it looked like so much fun. And while he was in there, the hole was now deep enough that instead of being up to here or up to here, it was now up to here. We'd say, put your hands down. And then we'd take and we'd cover him up and we're all laughing. And we'd bury him in the sand right up to his neck. And then we'd turn around and taunt him and run away. And we'd abandon him. And we'd go hide in those trees. And he'd be right here with the ocean coming in. And he'd start to feel all of the things that he felt inside. And all of the bugs that are underneath. And all of the little things that are there. And he started to get scared because he'd be 8 or 9. And he'd be there like this, and he'd start looking around, and he'd look, and he couldn't see backwards, and he'd be like this, and he'd panic. He'd panic. And we'd wait, and we'd laugh. Until finally, we'd go back. And when we went back, he'd look at it. And he'd look his best buddy in the eye, and he'd have tears, and he knew he wasn't supposed to cry. And he'd say, "Get me out of here. Get me out of here." And we'd take him out. And he'd be one of us. But that's the feeling that's been with me. That's Mrs. Jill Brown, where she is. Totally hopeless, helpless, lying there in bed. Instead of being 33 and pretty and 3 kids, she lies there day in and day out. And the worst part of it is not that her kids come in and the tears come down her, but the worst part of it is that the tragedy was so bad that she remembers who she was. Only if she didn't remember, but she does, because those tears come down day after day after day. And that's what she is. Now, the first hospital that took care of her did what they could and sent her to the second hospital, and they got rid of her, and they sent her over to the county welfare hospital, and they did what they could, and they sent her home, and they said, "We can't do any more. Mom, it's up to you. You run the 3 kids." You know, and her sister was with her, and she stayed and came down from up north, but now she's had to abandon her and go back to her husband that's a preacher up north. But she stayed for months, but now she had to leave. Her husband, the hospital, the doctors, a child, a sister, and now we're down to it. All that's left is her mother, Mrs. Brown, with a heart, has problem, 65, is me until right now. Now there's going to be you. And you're going to have to make that decision. Don't leave her hopeless and helpless. There's no coming back. This is it. Right now. And I leave her whole life, her kids, are right in your hands. Thank you so much.
Pain and disfigurement are 2 topics that are a continuing concern for a plaintiff's lawyer. Trying to find out ways in which these 2 abstract concepts can be made meaningful to a jury. In this particular case, Bill Colson was challenged with that same problem. A young woman, horribly disfigured, who went through 100 days of painful operative procedures during the course of her treatment. Listen as he very cleverly and very convincingly fills us all with the meaning of that pain. He also has to talk in terms of what disfigurement means to a young woman who lives in a world of beauty. One of the dangers of listening to arguments such as this is that, again, you tend to get the impression that this is some kind of a thought that happily came into the mind of Colson, perhaps during the trial, or maybe even as he stood before the jury. That's not so. He tells us that this was the product of a lot of thought, of conversations with his law partners, with friends, with laypersons, trying to develop a concept of how this can be conveyed. And finally, the product of this collective thinking was that he would convey this woman as living in a world of beauty, and how the devastating injury that she suffered would affect her role in that world. Another thing that you'll notice in this particular tape is, again, the way in which the jury's important role is emphasized. Not only the importance of what they were doing, but the finality of the result. And toward the end of the argument, we reach one of the classical endings. We'll await your verdict. We know it's going to be final, and we will be here to receive your appraisal of our case. Let's listen to Bill Colson as he deals with the world of beauty and the damages that should be given to a woman who finds herself an alien in that world.
Ladies and gentlemen, we're down now to the moment that this case is nearly over with as far as the lawyer's participation is concerned. You're going to hear what His Honor has to say about the law, and then you will make the decision that will live with Vicki Robbins for the rest of her life. And I'm sure that you realize what a serious responsibility this is. And I would like to leave you, as you go in there, with just a few quick thoughts. First, we've talked an awful lot about the explosion of this gas tank. And we're not going to talk about that now. Because I think that you're convinced, as I have been, that the evidence in this case, when combined with the law in this case, clearly points the finger of responsibility for the injuries to Vicki Robbins. Now, when you turn to those injuries, we find a case in which there's no conflict as to the injuries. Think about it for just a moment. In this case, you have heard no cross-examination of the doctors of any substance. They have not produced evidence to suggest for one moment that the burns that she sustained in this horrible inferno and explosion, that those burns were serious, that they are permanent, that they will affect her for the rest of her life, which will be certainly more than 50 years. So now we turn to that moment when we must discuss, as the last time, what are the damages that would be fair both to Vicki Robbins and the damages that would be fair to the Ford Motor Company. You now know, as I knew before the case started, that there is no conflict either, that she was on the critical list, that she nearly lost her left arm, that it was practically burned off, that she was burned horribly and excruciatingly with pain from here all the way down to her legs, that she's been through a series of graft operations, that she's been through many, many procedures that have taken place. You have heard about those 100 days in the hospital. And I know it would be nicer if I didn't mention those again. But because you're going to make this decision in just a short period of time, and you will be in there deciding her fate for the rest of her life, I must remind you at least a moment or two of what we talked about in this case during the testimony about those 100 days. And I'm sure that you will never forget, as long as you live, that when the doctor came in and tried to explain what it means to be burned that deeply with third-degree burns all over your body, all the way down here and all up into your neck, what it means in trying to keep her alive, and that the subject medically comes down to one of fluids, that you must keep a proper balance of fluids, and we've all had a blister, and that's what happens. That's nature's way of participating in the balance of these blisters through the balance of the fluids. But that what happened during this treatment is that in those 100 days, that it was necessary to change the dressing several times a day, as many as 6 times a day in a period of 24 hours. And that during that time, and we've all had one blister where you've had to take and to take it off, that she had the equivalent of thousands of blisters on her body at a time. And that those dressings would have to be changed 6 times a day sometimes. And that she would scream with pain. And we heard about it. We didn't talk long about it. I'm not going to talk but a moment about it now. But what we'll never forget, which was shown in these hospital records, where the nurses record and say, dressings changed, still screaming, 10 minutes later. And I asked the doctor on the stand, well, doctor, when you put this young woman through this, a young woman of 19, when you put her through it, why don't you knock her out? Oh, Mr. Colson, we can't do that. Why? Well, if we know that she's going to be here and she was there 100 days and we know these operations are coming and these grafts are coming, if we started to give her narcotics, we'd make her a hopeless addict. She'd walk out of here a complete, total addict, and she just had to live without any help of narcotics. You mean every day, every dressing pain? Yes, sir. But, doctor, I noticed that in the table of medications that were given, that there were sometimes, 7 that we counted them, that there were 7 times that morphine was given to Vicki. How did that happen? And he said, oh, I can account for that. He said, what happens? You know, the nurses that work in these burn units, he said they're very special people to volunteer to work in those units. But he said they do as well as they can. But when there's screaming that's going on and it lasts all night, or many hours and they are on that shift. Just sometimes we have to knock out Vicky in order to let the nurse survive. So that probably happened 7 times in 100 days. So think about that. Think about it when you're deciding the next 50 years of her life with permanent scars, that although we think that they're healed, that there will be problems in the future of breakdowns, a susceptibility to cancer. Think about that when you're deciding what's a fair verdict. And the loss that is there now, and certainly that pain will never be forgotten. That pain that existed not by the calendar of 100 days, not something that had happened 2 years ago, but by the tick-tock of a clock all day and all night long. When you decide what is fair in weighing what she's been through and will now go through, instead of 19 years of age, carefree, the beaches of Florida, sun, sand, surf, a beautiful sister like she was, what does it mean to be scarred? Well, I would love to talk to you instead of these final 5 moments. I'd love to talk to you for a day about it, because I've been taught and learned and tried to appreciate what it would mean. I would summarize it just this way. There's no coming back to this courtroom after today. We can't bring her back 5 years from now and have her sit there and tell you what it would mean. But I think we would know and could imagine that if she could come back, and you could come back, and I could come back, that she would be saying, no, I haven't gotten married. No, I don't plan to have children. Why? Because I want my children and my husband to be proud of me. What does it mean to have these scars? And I think that we could imagine her saying, if we could come back, the toughest part is that I am compelled to live in a world of beauty. And I didn't invent it, and I have ugly scars. But I live it in it. I was taught that as a baby, as a child, with nursery tales, with fairy tales, where the beautiful young woman gets the prince. I was taught it when I went to school in mythology with goddesses of beauty. I was taught it everywhere that I turned in poetry. Beauty, beauty, beauty. In art, a beautiful woman, Mona Lisa, a beautiful sunset. From Shakespeare plays to Hollywood productions to television commercials selling Fords, it's beauty. Always selling beauty. Miss America, what every woman pays to achieve beauty, clothes, cosmetics, time. And that's the toughest. I must live my 50-plus years ugly instead of reasonably attractive. So there I am. And here we are, folks. I think that she lives in a world of mirrors, very cruel mirrors. And you're going to decide what's fair. And I think that at the end of that testimony 5 years from now, if I could turn to you and say, award $100,000 for that year against Ford Motor Company, and you'd say, well, that's all right. She isn't working. She has trouble keeping a job when they see her and she goes in for an interview and they see her scars all over and they don't want to hire her, or she's tried to workplace and wear long sleeves and she tried to make sandwiches even in the, they got her out of there. You'd say, that's all right. Well, folks, the problem with it is this, that you must make this decision. You said at the beginning of the case, if we proved our case, you'd accept the evidence and multiply it with the law. Well, when you multiply 50 years times $100,000 just on that one item of damage, it comes to $5 million. Now, that's your decision. We shall be here. We shall await your decision. Thank you.
I seem to recall reading somewhere that the Chinese symbol for crisis was a combination of the symbols of danger and opportunity. When you hear the next fact situation, I think all of us will recognize it as a crisis, and I'm afraid most of us would only see the danger. A young woman killed, a migrant worker, a member of a minority group, a mother of 5 children, all of whom had different last names, and 3 of whom were illegitimate. Some of us would just throw up our hands at a situation such as that. But Bill Colson saw the opportunity in that crisis. He saw an opportunity to challenge the jury, to transcend the facts in that case, and to consider issues which were much larger. He challenges them in a very direct fashion to consider basic principles of American culture. And in doing so, he was able to take this seemingly hopeless case and translate it into a successful plaintiff's verdict. Listen to him as he accomplishes this artful conclusion.
May I proceed, Your Honor?
Yes, you may.
Ladies and gentlemen, you have now heard the end of the lawyer talk as far as the defendants are concerned, and you're about to hear the last of me in just a very few moments. And I have just a few moments to try to put in focus the differences that you've heard during this final argument between what I originally said and what these defendant lawyers have said to you. And I'd like to bring back into focus really what this lawsuit is about. And it's about Sandy Gonzalez, who was only 30 years of age and had come to this state and had worked in South Florida and South Dade as a migrant worker in the field. And she had moved on, but she worked her way out of those fields. And she got a job, first in a beauty shop, and then got a little tiny beauty shop of her own in Homestead. And she had 5 children. And she wasn't asking anybody for anything in this world. And those 5 children, the 2 oldest, were helping her to run that shop. And now she's gone through the negligence of these defendants. She's dead. She wasn't famous, and she wasn't special. She was just Sandy Gonzalez, and she lived in Homestead. She wasn't special except to 5 children that were her children. It was their mother jointly, but believe me, each individual lost their mother. I'm sure the youngest would say, my mama. The defense lawyers, in this case, referred 2 or 3 times to the subject of sympathy. When we were picking a jury, will you get rid of sympathy? His Honor is going to tell you that you shouldn't have sympathy as part of this case when you make your decision. And let me underscore it and say, I'm not asking you for sympathy in this case, but I'm asking instead for equal justice, and that's what I want to discuss briefly with you. We presented this case to you about Sandy Gonzalez from the witness stand, and they told you who she was and what kind of person she is. And now that she's dead, her 22-year-old sister has taken over these 5 children, and she's raising them. And I brought to you in a matter of less than 5 minutes 5 children that walked through and passed that little door and walked in here, and I stood them up and I introduced them to you. And they met you. You met them. And they looked great to me. And you didn't hear any testimony from them or any tears or anything about funerals. And you didn't hear any witness say they have nightmares or that they're failing in school. Wrong. We didn't do that. We have presented this case on purely evidence from that witness stand, and now it's your decision to make about that evidence under the law. These children, as I say, I think they're wonderful children. I think that the aunt is doing a great job with them. But they've been cheated. They each lost their mother. And how are you going to handle that in this jury room this afternoon? And I thought about these final moments, that if I could try to express it to you. And so let me try very quickly, in less than 5 minutes, what I think. You heard when we were picking you as jurors that both lawyers over here and I all live in Coral Gables, because some of the jurors were from Coral Gables. And it's a lovely neighborhood, and I'm very proud to live there. And I've thought to myself as I stood here, instead of it being Sandy Gonzalez, a migrant who is lost, and her 5 children who had 5 different last names, and instead of there being no fathers around and only 2 husbands who are long gone, that under those circumstances, what kind of fair trial would the children of Sandy Gonzalez have in this courtroom? In a courtroom in a state of Florida, in the United States of America, in a courtroom in this courthouse, in front of this judge, in front of that flag, would you really remember when I asked you in picking a jury, would you be able to give an equal trial to my client as much as anyone else in the United States if we're in a courtroom of law? Would you have any problem sitting here as a member of this community in Dade County, Florida, and saying, oh, I'd have a problem with that? And each one of you said no, regardless of what I have in my personal feelings inside of me, regardless of my past experiences. You prove your case, you show you're right and they're wrong, and I will see to it, and you look me in the eye, and you promise me that Sandy Gonzalez's children would have a fair trial. Well, here we are, and let me tell you. Suppose instead of Sandy Gonzalez, that my wife, Mrs. Bill Colson, had been lost under these circumstances and was deceased. And there wasn't a Bill Colson around, but it's Mrs. Bill Colson of Coral Gables. And her child was being represented here in court. And her child had this claim for the death of Mrs. Bill Colson of Coral Gables. And suppose that the lawyer in that case said to the jury in that case, I think that a fair verdict would be $500,000. I don't think I have just shocked you. I don't think of one of you have blinked and thought to yourself, oh, isn't he overreaching, or isn't he after sympathy, or isn't he being unfair? I think when you talk about Mrs. Bill Colson and what it meant to her child with the same name to lose a mother, I think you would think that the lawyer that represented her was being fair in this courtroom, in this state, in this country, with that judge and with that flag. So you have a decision to make. But let me tell you the problem. The problem you have is that there are 5 children, and these defendants managed 4 different times to find and to choose to read to you the 5 different last names. Why? To keep your verdict from being a fair one for each child because they have a different last name. Each child that lost his or her own special, the own mother, his or her mother, love, discipline, care, comfort. And so now you make that decision. You walk in there. You can make a decision that, hey, I didn't really mean it that way. Because you see, when you take a young woman who is deceased, and they have 5 children that are beautiful, at home with their aunt, waiting. And you have to multiply the $500,000 times 5, because each should have $500,000. So that's $2.5 million. So you will speak for this community. You will speak not for just this jury. You will speak to the issue of what is right about the loss of human life in the United States of America. You judge a civilization by what they think about when it comes to the subjects of women and children. You judge a civilization about what they think about human life. You judge a civilization of whether they think a human life is precious. Don't you know that I wish that we had an abstract justice that would let me wave a magic wand, or you wave a magic wand, and let Sandy Gonzalez walk in that courtroom, say thank you, and run get her children, and she wouldn't know my name or your name, but you can't do that. This is it. Somebody's got to win, and somebody's got to lose. And you're going to stand today, when you stroke your verdict, in that courtroom, in that jury room, as judges without black robes, you're going to strike your verdict of what you think 5 children who lose their mother have as equal rights in a courtroom in the United States of America. Thank you for your attention.
You've just heard 3 powerful closing arguments. And I'm sure that you can sense the electricity that must have surged through that courtroom when Bill Colson finished his final 5 on behalf of the children of Sandy Gonzalez. They were good exercises, not only entertaining, but valuable educational tools. Most of the principles that you've seen demonstrated in these tapes are easily negotiable for you in your own practice. The only difficulty is if in the event you were to attempt to adopt them in their totality, to take style and content and lift them and use them for yourself. That's what doesn't work. Several years ago, there was a trial advocacy seminar in which an experienced plaintiff's trial lawyer came and gave a demonstration closing argument, much as you've just seen by Bill Colson and Bob Cartwright. And he made the argument, which has become rather classic, dealing with the problem of the jury giving sympathy. And it went something like this. The judge will tell you that you're not supposed to give sympathy to the plaintiff. And that's a good instruction of law. We're not here to generate any sympathy on behalf of the plaintiff. The friends and the relatives who know her and know the injury that she's suffered give her sympathy enough. But you as jurors hold a unique role in the administration of justice. You alone can give her money damages, the one way in which she can get relief for the wrong that's been done her. Well, after hearing that argument, the student was quite impressed. And when he had his mock trial the next day, he thought he would lift both the content and the style as best he could and incorporate it into his trial. The problem was it came out something like this. We don't want your sympathy. We want money. And of course it fell flat. No good at all, because that incorporation cannot be made. Now there's one other difficulty that we have as we listen to a closing argument or as we consider a trial in its totality. We fail to analyze what it is about that closing argument that makes it good, that makes it effective. And so, without having any type of empirical proof as to what makes it work, we go ahead and incorporate whatever was done the time before, after we've gotten a successful result, thinking that we'll have the same successful result later. Let me share with you a story that I read some years ago that demonstrates the point. It was an essay that was written by Charles Lamb, and it concerned itself with a Chinese peasant by the name of Bobo. This was in ages past, before men even prepared their food by cooking it. But Bobo had this pigsty filled with some pigs, and one day the sty caught fire. He rushed out to put out the fire, and he was patting out the fire with the pigs. Part of his hand came in contact with one of the burnt pigs, and intuitively brought his finger up to his mouth in order to relieve the pain, and with his finger came a piece of seared flesh. He tasted the sweet cooked meat, and it was delightful. and he resolved that never again would he eat his pig raw. So you can imagine what happened the next time he had this yearning for roast pig. The pigs were put in the sty, and the sty was burned down. Lawyers go through that same sty burning procedure. We know when we got a good result. We happen to catch the magic of a good closing argument. And then we attempt to lift that argument and adapt it to another case without analyzing why it was good in the first place. These are the things that you as a trial lawyer must remember then. As you come into court and you try to emulate the skill and the art form that you've seen here today, remember that there are some basic principles that can be copied and can be incorporated into your practice. Remember that you have to be analytical and you have to identify those skills. And if you do those things, I'm sure that your next Final Five will be a real barn burner. But the important thing is that it will be a part of your own creation. You will have brought yourself into the courtroom, and you will have felt the ecstasy and the creative force that comes with the generation of a closing argument that is all your own.